Another video. So my name is Sanjeev Bhatia and I'm a graduate from National Law Institute, University Bhopal. And we have gathered today to discuss some of the legal terms that are important for your CLAT examination and other exams like AILET, MHCET. And these are basic English terms also included in this webinar that we are taking today. So you can look at these terms, put them in your head, and if you find them in any comprehension based passage in your legal aptitude or in AILET, in any other direct questions that you might get on your legal terms or maxims, so you are able to crack that code there. So today we'll start with a very basic legal term that all the students are aware of, right? So this first term is dolly in capax, right? So what is dolly in capax? So this maxim is drawn from the criminal law. Now dolly in capax means that children are incapable of committing crime. Now children belong to from the age of 1 till the age of 18, it's considered to be children in India also, right? But for putting the maximum of dolly in capax, you have to make sure that the child is below the age of 7 years. Now when the child is below the age of 7 years, he is not capable of any punishment, right? The government or the state cannot punish him for any crime. Okay, so if a child commits a crime under 7 years of age, even it's a murder or any heinous crime also, he cannot be held liable for such a crime. Why? Because that child is incapable of understanding the nature of his act, right? So the first term that we covered here is dolly in capax. Now, there is also a distribution of category that is being formed in criminal law for the same, right? So if a child is between the age of, above the age of 7 and below the age of 18, here the mental capability of the child is being judged. So if any crime is being committed, they check that how was the mental capability of the child while he was committing that crime. For example, there are two children, say a child of 7 years of age and there is a child of 12 years of age. Now the 12-year age child took a gold chain from a shop and told the 7-year-old that please don't tell anyone about this, right? So now here you can see that the child who was 12 years of age first has committed the crime, right? But that doesn't prove that he's aware of his actions. Now, in the second case where he tells the other child that please don't tell anyone, in that case we can see that he has reasonable amount of understanding of his act, right? So he can be held liable there. So he is not dolly in capax. But a child who's below 7 years of age, even steals, has no capability to get be punished, right? So first term is dolly in capax covered in this. Now coming to the second term, conjugal rights. What are conjugal rights? We have heard this term conjugal a lot of times. Now, the right of a husband or a wife to cohabit in one house, right? That is conjugal rights. There is something called the restitution of conjugal rights. That is the term that we have always heard around in the newspaper. Now, restitution is a different term. It is being used for getting back the people inside their homes, right? It is a term that is used mostly in divorce. But conjugal rights, if you see as the term, two, a husband and a wife have the right to stay in one house. That is defined as conjugal rights. So anyone who's getting married and has a legal marriage, right, which is registered under the Indian Act and or the Special Marriages Act or the Hindu law or the Muslim law, right, they have their conjugal rights in progress. Now they can come in control of these conjugal rights by the court also. If they want to take a divorce, they have to prove that they have been having a conjugal right before they have applied for a divorce, right? And if they apply for a divorce, the court will take into consideration what kind of conjugal relationship that they've shared so long, right? So then there is a cool off period in the same. Then there are other things that are also involved in a divorce proceeding and which is also called restitution of conjugal rights, which is RCR. Now coming to the next maxim, right, it's called estoppel. Now estoppel, if you see what estoppel literally means, what is the literal meaning of estoppel? It means to stop. Now if we see that if it means to stop, how it is being used in a legal scenario, right? When you read a sentence that the court put an estoppel on someone, right? What does that mean, right? So if you see under the Indian Evidence Act, the definition I've quoted on your screen, you can read it, but I'll read it word by word and explain you how it works exactly, right? When one person has by his declaration or act or omission intentionally caused or permitted another person to believe a thing, right? So you might go to the court, right, and you give a declaration, right? You give it in writing, or you intentionally said in the court that you have done a certain thing, right? Now you go to another proceeding and you say that you haven't done the same thing, and you have given a declaration that you have committed a certain act. Now the court can put an estoppel in this case by saying that you cannot coexist the truth that you've already told us, right? Now you cannot go back on your words, right? You cannot just say a lie in front of the court if you've given a declaration or you've intentionally proved through an act, right? So that's how estoppel works. So the court has the right to put an estoppel if they think that the person is contradicting the statements that he has given earlier, right? Now if you read further, if we see that neither he or his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing, right? So if you have given a declaration in the court or you've intentionally proved it, then you cannot deny that thing, okay? Then you cannot deny that truth because an estoppel will be applied on your declarations there. So that's how the court works in the case of estoppel. Now coming to the next part, ex officio. So you can see that I have put a picture of Mr. Narendra Modi here. Now I will explain you how it works, why I have put his picture, right? So now ex officio's literal meaning says that by the virtue of office, right? It's not a clarifying term that what does that means by the virtue of office. So say that it is also defined as denoting or relating to a member of a body who holds the role as a result of their status or any other positions. Now say that who's the chairman of Niti Aayog, right, which was earlier called as the Planning Commission of India. The chairman of Niti Aayog is always the Prime Minister, right? He's the ex officio chairman of Niti Aayog. That means that anyone who's becoming a Prime Minister of the country becomes the chairman of the Niti Aayog or the Planning Commission, which it was earlier called, right? So that means that PM, who's Mr. Narendra Modi, got the seat as a chairman just because he is the Prime Minister of the country. So basically, he got the chairmanship because of the virtue of the office he's sitting in. So I guess it's clear for everybody. Yeah. So you can see that he is the chairman here. Now coming to the next part, what is extradition? If a lot of people knows that in the past when there was drug wars going on in Colombia and there were drug wars going on in Mexico and in India also for Mr. Vijay Mallya, there have been a lot of this term being coming up which is called extradition, right? Now we'll understand what exactly extradition means. So when a person is being transferred from one jurisdiction to the other, right, because he's an accused or a convict or committed a crime in these other jurisdiction, right, by the law enforcement agencies. Right now, what happens in extradition, that it is always a combined effort, right? It is a cooperative law enforcement procedure. So if we say that we want to get Mr. Vijay Mallya back from UK, so we have to take in consideration the UK's law enforcement and the Indian agencies who will be going to arrest him, right? So that is the procedure of extradition. The crime that is being committed is committed in India, but you are being found in the UK. So what will be done? Their law enforcement will help the Indian law enforcement to get him back to the country. So they will extradite Mr. Vijay Mallya to India, right? Or they've been extraditing like in Mexico or in Colombia, where there were drug wars going on during the time of Pablo Escobar and Medellin cartels. If you've seen, there were a lot of extradition treaties that were being signed by the countries to fears the people in the poorer countries so that they are afraid of the law enforcements of United States of America or UK or USSR. So these are the terms that you have to understand and understand it in a way that you are able to get it in the paper while you are reading that passage, right? And there will be only a term that this person was extradited. Now, if you don't know what is the meaning of extradition, you will not be able to get the gist of the passage. So there are these certain English words also that you have to be well aware about, right? And these are all legal terms that you will keep on reading here and there. Very, very, very recently this has happened, so you will definitely get this in your exam. Now, coming to intravirus. Now, what is intravirus? So these two terms, intravirus and ultravirus, these two work together. Now, what is intravirus? Intravirus means within the power of. Now, what it is basically used as a term of constitutional law. It is also used in your administrative law. Now, a person who acts within his power is working intravirus. So say that a crime is committed in Delhi, right? Now, the Delhi High Court has the power and the jurisdiction to take a decision of it. So Delhi High Court is working under intraviruses of their powers, right? They're working intravirus. What does that mean? They are working within the power that is being provided by them by the constitution of the country, right? So that is the term intravirus. Now coming to ultravirus. Now what does ultravirus means? That a person is using or taking actions which is beyond his powers. Now say that there is a case that happened in Jaipur, which is in Rajasthan, right? Now Delhi High Court starts taking jurisdiction of a case that happened in Jaipur. Now it will be called that Delhi High Court was exercising ultraviruses on the Rajasthan case that happened, right? Why? Because it was beyond their powers and beyond their jurisdiction to take an action on such a case. So that is the proper meaning of ultravirus, right? Coming to lis pendens. This is also a very, very important term that is being used in CLAT exams earlier also. And it is just used as a normal English word, right? And it is also appeared in AILET exams. So you have to get aware of these maxims also, which are very small and easier ones, but they do appear in the exam sometimes, right? So lis pendens means a pending suit in the court, right? Which is a very straightforward maxim that you can read here, right? You don't have to understand it. You don't just have to learn it. And if you see it in the paper, you have to mark the right answer, right? And if you know that Indian judiciary is famous for having a lot of pending cases in the court because we don't have adequate amount of judges in the courts and adequate amount of lawyers in the courts. So that's why there is a lot of pending suits in Indian judiciary. So lis pendens is a very famous term that you will find here and there in the Indian judicial reference. Now coming to locus standi. Now locus standi is a term that you will listen to till the end day of your law school, right? Why is this term so important? Right? Now locus standi, basically if you see the English meaning of the term, it says the right to bring an action, right? Right to be heard before a court. Now what does this locus standi means? So if there is a right that is being affected, right, or is there anything else that has happened and it has violated my fundamental rights or any other right that is being mentioned in the Constitution of India, I have a right to bring an action in the court, right? Now, if you go to the court and if you see there are certain suits that are being filed which don't have any fundamental rights being violated or any constitutional right that is being violated, right? So the court will also say that you don't have any locus standi to bring this action in the court, right? You have no locus standi. Why is the court saying that? Because you don't have any right to bring an action in front of the court for the same, right? So locus standi is gonna be a very important part if you are also interested in getting into litigation. You will be keep on reading this term here and there very often. Now coming to the next term, modus operandi. Now what is modus operandi? Modus operandi is the word that is mostly used in criminal law. So if you see that if there is a murder happened in a society or in a in a country, they will always say that what was the modus operandi of that same issue, right? What was the method of working? Basically, how did it happen, right? So the police will first find the modus operandi. They will always say that the modus operandi of the crime was, right? Why is that? Because method that how the crime was committed. That's why the term modus operandi becomes very important in criminal law. But it is also a term that is used in civil jurisdictions and other jurisdictions also, like an administrative law. But if you find the most amount of usage of it, you'll find it in criminal law only. Now, coming to the next term, SUO-MOTO. This is also a term that we keep on listening in the newspapers very often. What does that mean? That SUO-MOTO cognizance was taken by the Supreme Court, right? Or SUO-MOTO cognizance was taken by High Court on the environmental matters. Like the Supreme Court of India took SUO-MOTO action on the pollution that is happening in Delhi. Now, what does that SUO-MOTO exactly means? That when the court takes the cognizance on its own, right? Why? Because it wants public welfare, or is there some right or law that is affecting the public at large, right? So the court has the power to take SUO-MOTO cognizance of the same. So say an administrative authority, say electricity department of Delhi is not working properly, and there are a lot of lags in the electricity that is being provided to the people of Delhi. Now, the court can take SUO-MOTO cognizance of administration of Delhi department, which is the electricity department, and can tell them to take actions and get the regularity of the electricity in the city. Why? Because it is affecting public at large and the court has the right to take such cognizance. So that is what the term SUO-MOTO exactly means. When the court takes the cognizance of its own, there is no public interest litigation that is being filed. There is no special leave petition that is being filed. It is just the court's decision to take an action on certain things that are happening in the country. So they take SUO-MOTO cognizance. So High Court can also take a SUO-MOTO cognizance, and a Supreme Court can also take a SUO-MOTO cognizance. Now parole. Now parole is a term that we have heard a lot of times during the case of Mr. Sanjay Dutt, right? That Mr. Sanjay Dutt was being left on parole for a very long period of time. That was also an issue that was happening a lot of times in such criminal cases. Now, what does parole means, right? What is parole? You can get it parole, it is the same thing, right? Now, when a prisoner is allowed to go home or outside the prison for a brief period of time during his imprisonment, right? It is different from bail, right? Bail is you are given a relief, right? But parole is that when you are punished, but then you are given a relief in between your imprisonment, right? And how does parole happens? Like a parole is given to a convict who's been a very good convict during the time of his stay inside the prison, right? The prison guards also give a recommendation that can he be sent on a parole or not, how was his behavior while he was there in the prison, and then the court decides what was the crime that he has committed, what was the seriousness of the crime that he has committed, and can such a person can be integrated in the society for a certain period of time. So that's how parole terms are being decided and how long a person can stay outside on a parole, right? Coming to the next term, perjury. Right now, perjury is a very, very important term that you have to know, is by giving false testimony. Anyone who goes to the court, or jhoot bol ke aata hai, anyone goes to the court and says a lie, right? Or gives a false testimony or gives a false statement for someone, then it is considered to be perjury. Now, perjury is also punishable. If you're going to the court and giving a fake declaration or a fake testimony or a false statement, then you can be punished under the Indian Evidence Acts because you've given a false evidence, right? So perjury is also a crime, right? So giving a false testimony in the court is a criminal offense. Now, ratio decidendi. Now, what does ratio decidendi? If you'll go into any top law schools or any law school of the country, you'll be making a lot of case reviews for yourself. Now, when you'll make these case reviews, you will find that you will be writing a lot of terms called ratio decidendi, obiter dicta, and things of that sort. Now, what is ratio decidendi, right? It is the main thing that you have to understand while you're reading any judgment around you. Ratio decidendi means that the reasoning of a judicial order, right? So a court is passing an order. What was the reasoning behind the court's mind while giving that order, right? They might have heard the whole case. what was the thought process that the court had during that proper order was being written is ratio decidendi. That is the reasoning for that judicial offer, right? Now coming to the next part, and this is the last term for the day. We'll be discussing, I'll be taking some questions after this. You can ask me questions regarding the same, but this is the last term for the day here, right? So locus criminis. Now what does that means? The place where a crime was committed. This is a straightforward term. You don't have to understand a lot in this term. You will directly put this term in the place where it is being asked. So most of these terms will appear in your paper as rather as a simple asking of a maxim, right? In AILET exam, they can directly ask you what do you mean by the term locus criminis, or in the CLAT paper where they will be giving you a comprehension based passage and they might just pop the term somewhere in between in the question where you're not able to get the meaning, right? So they might say that the locus criminis of the crime was, and if someone doesn't know what is locus criminis, then it will be a confusing thing for him to read and understand and answer that following question. So these basic English terms also has a mix of Latin language in it. So you have to understand that they might look similar to your English words but might not have the same meaning. So you have to definitely read the meanings of these English words also and understand how they are working in favor of you. Now, if you have any questions regarding these legal terms or any other question related to college admissions, you can just drop it in the comment box and I'll be replying to all those questions. And if you want to ask a question right now in this session and you want me to answer it live with you, you can just type it in the chat box that's there on YouTube. I'll be waiting for a minute for your questions. Till then, I'll be discussing another thing, that is the first part that we studied, right? The ex officio. Now the ex officio, you have to also understand that if you are studying ex officio, there are a lot of roles that are being given in the ex officio statements, right? So like a chairmanship of lot of administrative posts are always ex officio. Now there is something called de jure. Now what is de jure? De jure is when like a prime minister who's the signatory authority in a certain case is called de jure. So a prime minister is de jure of a country, right? He's just a signatory authority. Now, if you see both these terms together, you have to understand that they will always be appearing in a similar manner, but you don't have to get confused in both these terms, right? Now I've got some questions here. So yes, Shatendra, this is the first session. We are taking the first session today. Now Prerna asked me, sir, can you do the video on important articles also? Yes, Prerna, we'll do that also. We'll take up a video on the important articles and the fundamental rights and fundamental duties that are there. Okay, Siddhant asked me, I was confused about conjugal rights. Okay, Siddhant, I'll get back on conjugal rights. So conjugal right is a right of an husband and wife to stay together in a house. They have the right to cohabit, right? So if someone says that today you marry someone and you're not allowed to stay with them in the same house, so basically they are taking away your conjugal right. So you get a conjugal right after you have gotten married to someone, right? So it is a right of an husband and wife. Okay, so Satendra asks me how many current affairs to study for CLAT from which month of 2020. Satendra, I would always recommend students to start studying the current affairs from the month of March of 2020 till the day of their exam. Why? Because CLAT being an online paper and it is being happening on a computer format, we don't know when is the paper being created. So why to take a risk? So start from 1 month before, right? So most recommendations start from April, but I would recommend you to start from March so you have a background to start with. So March of 2020 till June of 2020 when your paper is gonna happen. So 13th June is the date for CLAT and 20th June is the date for AILET examination. So till 12th of June you can study your current affairs. So I guess this is it for today. We'll be joining you back on Friday with another session where we'll be discussing some techniques that you can take ahead for your preparation for other entrances. right? Like SLAT, AILET, and what are the important aspects of those exams and how you can handle that exam stress. So I'll be dealing with that issue on Friday. I hope you guys have learned some of the legal terms today. And before you leave the video, I would request you to hit a like and subscribe on the channel so that you can keep on viewing us again and again, and we can connect further on CLAT and other law entrances and help you ace those exams. It was nice having you all here. Thank you. Have a nice day and best of luck for your exams.